Thank you, counsel.
Thank you, Your Honors.
Ms. Flynn?
Mr. Chief Justice, and may it please the Court. This Court has recognized that cases like these, where state defendants disclaim the use of race in line drawing and argue that any racial disparities are simply the result of a correlation between race and political affiliation, present special challenges for trial courts and require an especially sensitive inquiry. As part of that inquiry, plaintiffs bear the burden to disentangle race and politics and show that race drove the mapmakers' decisions about where to place a significant number of voters. The district court found that plaintiffs had done that here. But this court's also been clear that on appeal, this court's job is more straightforward. Racial predominance is a factual finding subject to clear error review, even when there's a politics defense. The court has also repeatedly rejected attempts to impose unjustified evidentiary hurdles as a matter of law on redistricting plaintiffs. Defendants' arguments for reversal in this case contradict those settled principles. I welcome the court's questions.
If we find no intent to discriminate or that there was a vote on the vote dilution claim, that's what I'm more interested in. You seem to want us to send it back on that. But if we find no intent, should we, or should we just simply resolve it here?
So our position on the second claim is that if this court were not to affirm on the first racial gerrymandering claim and not find racial predominance there, that this court should remand on the second claim because we believe the district court used the wrong legal standards to evaluate.
And what should that
claim.
Standard be?
So the district court simply sort of took the findings it had made on racial predominance and the Shaw standard and carried them over, but the intent standard is different for an intentional vote dilution claim. It's the Arlington Heights inquiry that this court...
And that is, it's again, the vote dilution claim. It seems as though those were collapsed into one another, the redistricting and the vote dilution, and dealt with on the same standard. So I'm wondering if the standard is intent with respect to the dilution claim. If you don't see that intent here, why should we remand it?
Well, I don't think the district court made the findings under the correct intent standard for you to evaluate that. I mean, as I mentioned, the district court just asked about racial predominance, but they are different intent inquiries. For intentional vote dilution, you're asking about a specific intent to dilute the voting strength of the minority population, not just whether race predominated in the line drawing decisions.
And you're saying we couldn't determine that on the record that's here?
I think this court should follow its usual practice and instruct the lower court about the correct legal standards and then send it back for that determination to be made in the first instance by the court looking at the full record, if the court were to have occasion to reach that second claim.
I guess my question is, I'm sorry, Chief.
Ms. Flynn, your office reviews a lot of these voting cases, right?
Well, our enforcement work is typically in vote dilution, not in racial gerrymandering per se, but yes, of course, we've been involved in these cases.
Yeah, putting that aside, have you ever supported the plaintiffs in a case in which there was no evidence of any direct discrimination, no alternative map, no oddly shaped districts, and a volume of political data? Can you think of one where your office has done that before?
Well, this might be the first case where there hasn't been sort of direct evidence of an attempt at VRA compliance or the like, but I do think that when you brought up the alternative map, I do think that the plaintiffs offered expert evidence to answer that same question about was it race or was it politics that were driving the line drawing decision.
Yeah, that's one of the things I brought up. I also brought up the absence of direct discrimination, the absence of oddly shaped districts, the lack of, the great volume of political evidence. And throw in another one, anything that all of that has been done, it is alleged on racial basis, to change the population in the district of the desired voters by 1.3%. My point is a clear one. Have you ever seen anything like this?
Well, this court has affirmed, I believe, on a circumstantial record. I think in North Carolina versus Covington, the court said that the state was completely not denying using race. The legislature told its map maker not to look at race, and this court still said it was permissible for the district court to find, based on demographic information and information about the shape of the district, that race was in fact relied upon. I'd also say here the district court did look at traditional redistricting principles and find that they were subordinated in this instance. For instance, this new district is not contiguous when the previous district was. Of course, there was previously a Charleston County divide, but this is, I don't think, the case that the traditional districting principles wholly supported the state's story here. And I will sort of go back to the expert evidence in this case. In our view, we think the Ragusa expert and Liu were the most probative on the question we've been talking about today, which is, was it race or was it politics that were driving the district lines? And Dr. Ragusa took the methodology in Cooper, arguably improved upon it by looking at BTDs, at precincts, rather than voter by voter, which is what the Cooper expert did. And then he also ran a regression analysis to further isolate out the effect of race from politics.
Counsel, I want to just explore the alternative map, non-requirement requirement thing
Sure.
for a minute. Everybody seems to take as given that the legislature here did seek to pursue a partisan gerrymander, if you will, or partisan tilt, I think is their preferred term, and that that's permissible under this court's precedents. We start with that as a given, okay, right?
Yes.
Okay. And that the plaintiff bears the burden of overcoming a good faith presumption that the legislature is doing just what it says, right? Mm-hmm. How do you prove that they are acting in bad faith without showing that they could achieve their objective some different way?
I agree that could be a probative piece of evidence in some cases, and I think that's what the court said in Cooper. What we're pushing back on is the idea that you need to have, as a matter of law, for the plaintiff's case to even get off the ground, an alternative map that checks all the boxes.
I get that, and I'm wondering why. I mean, normally if a plaintiff bears a burden of proof, you have to show that it would have happened but for, this change in the world. And I think here the analogy would be, and I'm just exploring this, I don't know, all right? I could be wrong, probably am. But in a but-for world, the legislature could have achieved its partisan purposes, nefarious, happy, whatever you think they are, in some other way, without doing what it did that you're objecting to. And here there's no evidence that the legislature could have achieved its partisan tilt, which everyone says is permissible, in any other way. What do we do with that with the presumption of good faith?
So I have a couple of responses to that. First, I do think the expert evidence answered the same question. An alternative map says, if you were really relying on the thing you said you were relying, wouldn't you have done, maybe you would have done this other thing instead.
I could have achieved the same partisan objective 15 different ways. And with map drawing technology and computers, they spit out maps by the thousands these days. I would have thought that would have been a relatively modest burden.
But
what am I missing?
It's still just a way to answer the question, what better explains how the lines were drawn, and we think the expert evidence does that. The other thing I would say about creating this kind of requirement as a legal rule, rather than something that can be a piece of evidence that both sides can make arguments about, is that I think it's going to add even more complication to these even very, very complicated cases. So my understanding is that defendants want their alternative map requirement to be limited to circumstances where there's no or meager direct evidence. So I think first you're going to have a mini trial on, is this a case where there's sufficient direct evidence or not to bring this rule into play? And then I think you're going to have litigation and probably appeals on what the alternative map has to do.
No, I'm not even asking about, I'm really not interested in whether it's a requirement or not. I'm just as a factual matter, wouldn't have been the simplest thing to do if I'm plaintiff and I want to show the defendant can achieve its permissible ends in some other way. I think in most other scenarios, in a tort case or an antitrust case is what I'm thinking about, I would show that there were 15 other ways to achieve that which you said you wanted to achieve. And that would be really strong probative evidence, whether it's required or not, put that aside, that hey, you're not telling the truth about what you're up to here.
I agree it can be very probative evidence. I can't really speak to why it would be easier.
Should its absence here tell us something?
I don't think so, because I think the plaintiffs offered 2 experts that went unrebutted to answer the same question. I will also just point out that I believe there are maps that are in the record that did have a higher BVAP but stayed based on the 2020 election data as a Republican-leaning district. So, I believe those maps are the first House staff plan, and I think there was one from a Senator Saab that also had that. So, what's easiest for a plaintiff to do to prove their case, I'm not really in a position to sort of speak to their litigation choices.